This conference will now be recorded.
Okay, I guess it's working. I guess we're recording. All right. Well, the hearing, let me change my lighting just a bit here. Need a little more light on this. The hearing will please come to order. Good afternoon. I'm John Galt, the Sammamish hearing examiner. It is now 1:03 p.m. on June 5th, 2020, and I want to welcome you to this afternoon's open record hearing. The application that we are hearing this afternoon is a zone reclassification request filed by Frank and Maureen Santoni. The file number for this application is ZONR 2019-00061. My introductory remarks today will be a little bit longer than normal because we're holding this hearing remotely due to the restrictions necessitated by the current COVID-19 pandemic. I apologize to you all for the length of these remarks, but I believe that they're necessary to preserve everybody's due process rights. Today's hearing is being conducted remotely using a software program called GoToMeeting. People may participate in this hearing by computer with audiovisual capabilities or by telephone. This hearing is being recorded by a system that's built into the GoToMeeting program, and that system records both audio and visual, audio and video. So I would remind all computer attendees to keep that in mind. What you're looking like on the screen is being recorded for posterity. I am the presiding officer of this hearing, but Ms. Tiwana of the city staff is the organizer of our session this afternoon. She can control when audio is turned on and off. I believe that we can individually do it ourselves, but she, I believe, can override us in that regard. I would ask that Ms. Tiwana keep my audio on throughout the hearing and everybody else is off until they are recognized to speak. And I ask for that so that I don't accidentally hear side comments that I'm not intended to hear, so that we can control people talking over one another and to help control the flow of the hearing. Please be advised that I expect that all persons who are actively participating in the hearing at the time they testify must turn their video on. Each witness is a party of record, and other attendees may also receive copies of the notice of decision, even if they do not testify. We normally have a form available in the hearing room where you may sign in to become a party of record. And we obviously can't do that here because we are meeting remotely today. Therefore, I think there are two options that you can use. Number one, when the hearing is over, I will check out. The rest of you can all stay in the hearing, and then folks can give either Ms. Tiwana or Ms. Hatchie, they both be on and they could hear you, but you can give them your mailing and or email address. I believe the city would greatly appreciate it if you are willing to receive the notice of decision via email, given the fact that everybody's working remotely these days. The other thing you could do would be to send an email to Ms. Hatchie and tell her your contact information. I will let her tell you her business email address after the hearing's over. There was, as there always is, an opportunity for anybody to submit written comments at any time prior to the hearing today. Any comments received in that standard fashion will shortly be entered into the record as exhibits. In an in-person hearing, attendees may also submit written materials in person during the hearing. And again, that obviously can't easily happen in this remote hearing format. Therefore, as we go along, I will try to remember to ask each witness after they've spoken if they have any written materials that they would have provided at the hearing had we been meeting in person. If any people do so indicate, then at the end of the hearing, we'll leave the record open and I will explain the process that will follow at that time if we need to leave the record open. The sequence that we're going to follow for our testimony today is the same as it would be if we were meeting in person. Once my introductory comments are over, we'll begin with testimony by the applicant, and that will then be followed by testimony, or excuse me, we'll have direct testimony, followed by rebuttal testimony, followed by optional closing statements. And the direct testimony and the rebuttal testimony will start with the applicant, then city staff, and then any members of the public. Optional closing statements are not available to the public, and we use the reverse order for the applicant and the staff, meaning that the staff would go first on closing and the applicant second and last. You'll notice in that sequence that the applicants speak first and they have the opportunity to also speak last. And that's appropriate because the applicant bears the burden of proof. What that means is quite simply, it's up to the applicant to show by a preponderance of the evidence that their application complies with the criteria for approval of a zone reclassification. The applicants can meet that burden through their testimony today, through written documents that become part of the record of the hearing, or any combination of the both. A zone reclassification is a type 3 proceeding for zone reclassifications which are consistent with the comprehensive plan. Type 3 applications are subject to an open record hearing by the examiner. That's what we're here for today. I then have a period of 10 working days after the close of the hearing in which to evaluate the testimony and the evidence that's offered and to reach and issue a decision. My decision will be final with the right of reconsideration and appeal to Superior Court. An explanation of the reconsideration and appeal procedures will be included with the decision, and so I won't take any of our time to go over that today. The city will mail or email a copy of the decision to the applicant and to each person who becomes a party of record. I'm required to base my decision primarily on the criteria set forth in the city code for the review of zone reclassifications. There are two sections of the city code that contain those criteria. They are both in chapter 20.10, and they are sections 200 and 210. In addition to those specific, I do consider any other relevant requirements and provisions of the city code, adopted city plans and policies, state law and rule, and judicial precedent, all applied to the facts that are disclosed by the documents and the testimony that's entered into our record. I reserve the right to take official notice of applicable case law, provisions of state laws and rules, provisions of the city code and the comprehensive plan. Are there any questions regarding hearing procedures? Are there any objections on jurisdictional grounds or concerns regarding conflict of interest? Hearing none, we will move right along. Mr. Santoni, if you could turn to. Thank you.
So, Mr. Examiner, we tried to specify.
I have a couple more things to do before we get to our testimony, sir. So just hang in there just a bit. First, I want to indicate that I made a site familiarization and saw your property on May the 23rd. I did not go onto your property to view it. Rather, I viewed it from 228th and from the development to your north, which had a street that allowed me to drive around through the street and come back out. My site visit is not intended to be a substitute for anybody's testimony and evidence. I go to the site simply because it makes it easier for me to understand your testimony as you try to verbally describe things to me. So please remember that if there are any important things that I need to know about the site and the surroundings, it's up to you to get that information into the record. It can be done through documents that are submitted or through testimony. The city staff has gone through the application materials and identified a total of 19 items in its file, which the staff believes will have either procedural and or substantive value to me as the decision maker. Excuse me. Those 19 documents have all been available on the city's website for public review for the past week or two, and therefore I'm not going to take time this afternoon to identify them individually. Rather, I herewith enter into the record of this hearing pre-filed exhibits 1 through 19. 1 through 19 are now exhibits. Okay, now we get to see if we have a way that we can hear from the Santonis in a way that we can understand. Am I the only one who's hearing?
Okay, so
Can you hear us?
Yes, with difficulty.
The phone connection is not working. Miriam, is there any way you can help us with this?
I'm not sure why the phone isn't working.
I dialed in the number we had yesterday, and it said the access would not be set.
So you guys, if you open your email, I sent you the dial-in and access code for today. So or in the chat, if you look in the chat on here in that little speaker hole, you'll find the code for this meeting and I posted it.
Oh, and Snowflake?
Yes.
Yeah.
Okay.
And then click phone, and then you'll see the dial-in information.
Okay, I got it. Just give me a second. I'm going to dial it right now.
Okay.
Ms. Tawana, can you turn off the Santoni's mic?
Okay, so we are on the phone.
And that is crystal clear. But now it's off. Oh dear. Go ahead.
How
now.
is it working now?
Yes. Hallelujah.
Okay, he said it's working very well now.
Okay.
Okay. Now, Mr. Santoni, everybody has sworn in who's going to testify. So before you start telling me it, what did you just do? Can you hear me?
Yes, I can hear you.
Okay. You need to raise your right hand. You swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth.
I do swear.
Thank you, sir. For the record, please tell us your name and how to spell it.
Okay, it's Frank Santoni, FrankSantoni.
Thank you, Mr. Santoni. Thank goodness the phone works, because that is 1,000 times better than what I was hearing before. You're perfectly clear. Go ahead now.
Okay, I've got it, not too long, I've got a couple of statements. We are requesting to change our reserve zone TCE to TCB. We think the application should be approved because the city created the reserve zone specifically for this purpose. It will allow the property to be consistent with the zoning and development immediately adjacent. We are at the culmination of an almost 4-year process, reviewed, studied, and approved for go-ahead twice by both the Planning Commission and the City Council. The changes to the comprehensive plan have already been approved. And that's all the comments I have for right now. My wife would like to talk.
Okay, thank you. Ms. Santoni, if you raise your right hand, please. Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please tell us your name and how to spell. Well, don't have to spell the second name, but how to spell your first.
First name is Maureen, Maureen.
Thank you. Okay, go ahead, Ms. Santoni.
Thank you for being here, Mr. Hearing Examiner. We lived in our house for 39 years. We designed it, raised our children there, and enjoyed its quiet solitude. We were forced out by the 75 townhouses that were built next door. We expected buffers, but that did not happen. Instead, 15 units looked directly on us. We couldn't stay. Our privacy was gone. We found a lot about a mile away and rebuilt the house. We need to sell to cover the cost of rebuilding. Thank you.
Thank you, ma'am. Okay, do you folks have any documents that you wanted to submit beyond the ones that we already have in the record?
Everything we've submitted is in the package. We have nothing new to submit.
Thank you, sir. Let's see, Mr. Johnson, you're going to be the lead speaker for the city, is that true?
Yes, Mr. Hearing Examiner.
Okay, would you raise your right hand, please? Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. For the record, please tell us your name and how to spell it.
My name is Andrew Johnson, AndrewJohnson.
Thank you, sir. Go ahead.
Thank you. We have no further comment. We do have one comment relating to our staff report. If you so choose, would like us to provide that to you.
Please.
We would like to clarify a mistake made on the staff report after the report had been published. On page 1 of the staff report, under key dates, the completeness determination shows a date of February 3rd, 2020. The actual date, as shown in Exhibit 8 and reference to on page 3, paragraph 4 of the staff report, the actual date was February 4th, 2020. Thank you, Mr. Examiner.
Thank you. Does staff have any additional materials that you would need to submit into the record?
No, sir, Mr. Examiner.
Okay. Let me ask just one question at this time. I noted in the materials that the period on the SEPA DNS expired on the 26th of May, I think it was. Did any timely file an appeal?
No, they did not, Mr. Examiner.
Thank you. And I might as well go ahead and ask this one. The 120-day clock, are we Are we within the 120 days or are we beyond the 120?
We are under the 120 day. I can give you a breakdown if you'd like, but
No,
we are
just,
at 116 days.
okay, thank you.
Thank you, Mr. Examiner.
Now, what I'm going to do is just go down the line on the pictures and see who wishes to offer testimony as a member of the public. And I'll go on my screen. I'm in the upper left and Ms. Tawana is next to me. I don't know whether everybody's screens work the same way or not. I had a lot of fun in the hearing I did yesterday on Zoom because their pictures would move. They'd go from one corner of the screen to another, and you're looking in a certain direction, and all of a sudden they're gone, and oh, they're down here now. So I hope you all don't move on me. Ms. Tawana, did you wish to offer any testimony? She does not. Yeah, if you don't want to, and if your video is showing, you can just shake your head as she did. Mr. Pyle.
Microphone management. I do have no comment at this time, simply observing.
Thank you, sir. Ann Pearson.
I have no comment. Thank you.
Thank you, Ms. Pearson. Avril Beatty. No comments. Lita, I'm sure is going to shake no. Okay. If any of you don't know, Ms. Hatchie is Deputy City Clerk, and she's my hearing clerk during all my hearings. Miriam Leitner. No. Victor Solomon.
I don't have any comments. I'm a traffic consultant for the applicant and available for any questions.
Thank you, sir. Paul Stickney. Mr. Stickney? We'll scroll by. He may have run away from his machine. Kelly Hildy? No. Jasveer, I think that would be Jasveer Singh. He's a city staffer. I presume the answer is no. Okay. And Steve Roos?
No comments.
None. Thank you, sir. Mr. Stickney? Do you wish to be heard?
No, I had off the mic. No comments.
Thank you, Mr. Stickney. Okay, that concludes the direct round of testimony. Let's see if there's, to my ear, there was nothing to rebut, but I still will give you the chance. Mr. and Ms. Santoni, do you wish to offer any rebuttal testimony?
We have no rebuttal testimony.
Thank you, sir. Mr. Johnson?
No, sir, Mr. Examiner.
Thank you. And since no member of the public offered any direct testimony and there's been no rebuttal testimony, there's nothing for anybody to rebut. Does the staff wish to offer any closing thoughts?
Not at this time, Mr. Examiner.
No, this is the only time. No, okay. Mr. Santoni, you have the last word if you want to take it.
So thank you for the last word. We just want to thank you, Mr. Hearing Examiner, for being here today. Really appreciate the time, and especially the staff for setting all this up. I know it's a tough time for everybody, and this is going as smoothly as we would ever anticipate. So thanks very much for city staff for doing all the work for us and with us.
Thank you, Mr. Santoni. This will conclude the hearing, but Ms. Tawana, don't turn the recorder off just yet. If that's the wrong, it's terrible having two machines and two mice that you have to remember which mouse works which machine. I don't frequently give an oral decision at the end of a hearing. I do sometimes. So this is not a totally unusual experience in Sammamish, but it's still relatively rare. About the only time that I do an oral decision is in a situation where there has been no controversy, no opposition, frequently no public testimony at all, no lurking issues hiding somewhere in the bushes, or I have been known to give decisions when I felt that the applicant appeared so nervous that I was afraid they'd have a heart attack before they got home if they didn't know what the outcome was going to be. This is not that latter situation. However, I do think that the documentary evidence that's been submitted overwhelmingly shows that I should grant the rezone, and that is what I will do. The criteria require in section 20.10.210 that I find at least one of 3 situations to exist. And the second one is that the adopted interim comprehensive plan or zoning specifies that the property shall be subsequently considered through an individual reclassification application. In fact, this past January, the council changed the comprehensive plan designation of this site to TCB and essentially begged me to grant a rezone of the property. Those are my words. That's my interpretation of what ultimately happened. And you clearly meet that. The property is now designated TCB on the comp plan. This rezone absolutely implements the comp plan. I see no earthly reason why it should not be granted. I also do not find any reason to impose any kind of special conditions on the rezone. So it will be my decision that I am granting the rezone from TCE to TCB. I will issue a written decision that so states. Now you may be wondering, okay, he's told me orally what he's going to do. What good is it to me? Well, the simple answer is that it means I can't change my mind now, even if suddenly later on tonight I had second thoughts and thought, gee, I don't think I want to do that. I have promised you on the record that the rezone will be granted. You can go to sleep tonight knowing that it will be granted. You probably won't get the paperwork until early next week, maybe. Although I am going to be staying home this weekend because the weather's not supposed to be so hot. So I may get this one done over the weekend, and in which case I would email it to Ms. Hatchie probably Monday morning or maybe even Sunday. So, but I wouldn't expect her to do anything with it on Sunday. Okay, well, I don't have anything else that I need to hang around for. We really don't have any parties of record because everybody said they didn't want to testify. But Ms. Hatchie, you have the Santoni's email address, I presume? She indicates she does. Okay, well, I'm going to see if I can check out of this. There it is, leave the meeting. And if you folks want to stick around for some reason to chat, you may, but I'm going. I think I have to click a couple times before I really disappear, but I'm going to do it right now. Thank you all very much. Have a good weekend. Stay safe.
Thank you very much. Is there anybody that would like a copy of the decision emailed to them? I know the Santonis will, but Ann Pearson.
Oh, yes, please. I would love a copy.
The staff have her email, or you could give it to me now.
I'll put it in the comments right now.
Okay, thank you.
I just wanted to say congratulations, Frank and Maureen. I hope you get to go celebrate soon. Okay. Have a good weekend. I heard they deliver wine and such now, so definitely do that. You deserve it.
Congratulations.
Take care.
Okay.
Thank you.
May I stop the recording?
Is everybody done? I am. Thanks, Cynthia.
Yeah, no problem. Take care. Have a good weekend.
Okay. You have a good